All right, let's get started. Hello, everyone. I'm Roland Vogel, Executive Director of the Stanford Program in Law Science and Technology and of Codex, the Stanford Center for Legal Informatics. It is my pleasure to welcome you all to this fireside chat with Professor Miriam Wimmer, who is the Director of the Brazilian National Data Protection Authority. This event was developed by the Stanford Program in Law Science and Technology and its Center for the Digital Economy, in collaboration with the Brazilian law firm Pinheiro Neto, which is a member of our affiliate program. The mission of our program is to bring to the fore and advance insights and engage the public and other stakeholders on critical issues affecting the law and technology community. So this event is really a perfect example for our continuing efforts towards that objective. Professor Wimmer will be joined by Rafael De Cunto, who's a senior partner at Pinheiro Neto and who's in charge of the firm's Palo Alto office. And the event will be moderated by Lgpd, who's a leading expert also on privacy law, who until recently served as the consulting director of the Stanford Center for Internet and Society. So thank you to everyone who helped put this unique event together. And thank you, Professor Wimmer, for making yourself available. Thank you, Rafael. Thank you, Al. And with that brief introduction, I will turn it over to Al.
Thank you, Roland, and welcome everybody. Good day to everybody. This is a wonderful program, and Roland, thank you and law school and Rafael for letting me host this fireside chat. I had said a little earlier when we were chatting about this program that the idea of a fireside chat was born in the US under the presidency of Franklin Delano Roosevelt in the middle of a depression and entry into World War II, where he would get on the radio and spend his time to give comfort and to calm the nation and give them hope. I don't think the Brazilian privacy law requires that, but in light of the complexity and the breadth of it, we're really fortunate, Miriam, to have you here to give us a little bit of an explanation, maybe calm us down a little bit and maybe motivate us a little bit as well. So would you give us, an overview of the law from your perspective as we begin on this privacy journey in Brazil, which is very exciting?
Sure, Albert. Thank you very much for the quick introduction. Thank you also, Roland and Rafael, for organizing this event. I very much appreciate the opportunity of speaking to this wonderful audience. I see we have 130 participants by now, which is very expressive. So thank you once more for the opportunity, and I hope to be able to provide some useful information. So I think I'd like to get started by providing some context on personal data protection in Brazil, since not all of our audience members may be familiar with this. In fact, we began discussing a personal data protection law in Brazil approximately 10 years ago, 10 to 12 years ago, perhaps. And early discussions were carried out within our Ministry of Justice, within the National Secretariat for Consumer Relations. And it took quite a while, finally a draft bill of law was agreed upon within government and sent to Congress in 2016. And then we had another 2 years of discussion. And I think it's fair to say that over this period, everyone learned a lot about data protection, which was something, quite foreign to us. Our law was strongly inspired by the European approach. And so while we did have several different fragmented rules dealing with personal data protection before the Lgpd, in our constitution, for instance, we have rights to privacy, to protection of intimate life, to protection of communications. We also had our consumer protection code. We had a large number of sector-specific laws. But it was only when Lgpd was approved that we, in fact, began to have this new horizontal approach to personal data protection, which of course raises a number of challenges in terms of interpretation, because now we have sector-specific rules and horizontal rules and a large number of governmental bodies involved with these issues. So we do have quite a complex landscape in terms of enforcement. But it was a law that was, very much awaited for here in Brazil. And in fact, during the final stages of discussion in Congress, we had a very unlikely alliance between academia, civil society, and the business community. There was actually a letter that was signed by, I think, over 80 different organizations from these very different sectors, so unlikely bedfellows, so to speak. And this, in fact, provided for lots of pressure for the law finally to be approved in August 2018. And the law was approved, but there was a presidential veto to one of the articles that was in fact related to the creation of our National Data Protection Authority. And this was for formal reasons, for reasons of inconstitutionality. And then in December 2018, there was a presidential provisional measure creating ANPD, formally only on paper, but in fact, ANPD was only created last November when our law finally came into force, and then a presidential decree was issued to create ANPD. So LGPD is a law that is quite similar to the GDPR in many aspects. And of course, when we look at a European approach towards data protection, usually this is based on the understanding that personal data protection is associated to fundamental rights of individuals. So the right to privacy, the right to personal data protection, but also on the understanding that personal data is also an important economic asset nowadays. And I think this is particularly true as we go through this process of digital transformation, and as organizations and government itself becomes more intensive in the use of personal data. So our law seeks also to create a balance between these two aspects of personal data, and in a manner that is quite similar to GDPR, provides for rules on data subject rights, on principles to guide personal data protection that are quite similar to the OECD principles, by the way. Also rules for processing data within government. And finally, our law provides for the creation of ANPD, which is our National Data Protection Authority, which I think is also an essential piece of, this jigsaw puzzle of personal data protection. ANPD was therefore created last November. On November 6th, it actually formally came into existence. And we are a body that is currently connected to the Presidency of the Republic, which is a provisional status because the law in fact says that we have to go through further transformation over the next 2 years, and I'll be happy to go into that later on. And we are headed by a board of 5 directors who have all been examined by Senate and then appointed by the President of the Republic. And we are quite a small organization. In fact, our structure provides for 36 different positions, included the 5 directors. So it's really, in fact, a very, very small organization when we consider that Brazil has 230 million inhabitants. And this makes our job, in fact, very challenging. And we are structured in a very simple manner. So we have, for instance, we have the 5 directors. Each director has an advisor, someone to help them. And then we have our ombudsman, we have our legal office, we have our internal audits department, and then we have administrative staff. And finally, we have 4 different departments which are sort of in charge of our core business. One is responsible for international and institutional affairs. So they're dealing basically with international relationships, but also with the many different enforcement bodies within the Brazilian public administration. Then we have a department responsible for technology and research, which works sort of like a think tank. So these people are always, trying to keep one step ahead and figuring out where technology is going to take us and what the new business models look like. Then we have one department responsible for monitoring and sanctioning. And finally, we have a department responsible for regulation, for issuing norms. And in fact, it is a small structure, and our role of responsibilities is quite large. We have several different roles to play. So as well as issuing regulation, applying sanctions, monitoring the market, we also have the responsibility of playing an educational role. So in fact, here in Brazil, where we do not have a long history of personal data protection, it's very important for us to provide education, capacity building, provide guidance, sort of help people to figure out what they're supposed to do with this new complex law that was just enacted. We also have a role regarding international data transfers, of course. And we have a very important role, which is that of providing final interpretation of the law within public administration. So this is a particularly important responsibility since, as I mentioned, we have a very large number of different governmental bodies that may deal with some aspects of personal data protection. And of course, it would be very confusing if each of these different bodies could, go out on their own and interpret, for instance, what legitimate interests are or how to transfer data internationally. So in fact, we have this role of coordination within the government, not only at federal levels, but also at state level and our municipalities. And I think this will, in fact, be a very challenging role to play, since we also have a very active consumer protection system with more than 900 bodies, local bodies spread throughout the country. Well, so last November, the directors were finally appointed formally, and we were taken to a meeting room and people said, okay, you guys can get started. And we were all looking at each other's faces and sort of figuring out how to begin. And what we did do during those early days was to come up with our strategic planning and also with our regulatory agenda. So at this point, I think our priority is to be very clear on what our plans are, to be very transparent about what we're doing, because in fact, this law is new for everyone. I think everyone was, quite concerned about what ANPD would look like, how we would act. And I think the message we want to pass along at this point is that we wish to be very straightforward, very transparent, very open to speaking with different stakeholders interested in personal data protection. And for this purpose, we published these two documents. So first of all, our strategic plan, which is a document that sort of sets out our priorities over the next 2 years. And these priorities include, firstly, strengthening our culture of personal data protection in Brazil. And this involves, of course, educational measures, capacity building. It involves also entering into formal cooperation agreements with these many other public bodies that have responsibilities that relate to ours. Secondly, our strategic plan looks at our formal regulatory environment, and we realize that LGPD is a very complex rule that has many points that are still open to regulation. So this is something we wish to focus on during these early stages. And finally, our third pillar in our strategic plan involves, in fact, ANPD's actual structure and institutional status, because as I mentioned, we are currently a very small body connected to the Presidency of the Republic. And of course, this is something that is perhaps not an ideal design for a DPA. And so we hope over these next 2 years to work towards achieving a more independent status and to having more people working with us and better budgetary conditions in order to allow us to carry out our important responsibilities. And the second document I mentioned was our regulatory agenda. And again, this is not a legal obligation, but it was a decision made by the board of directors in order to communicate very clearly what our priorities are. And I think you can imagine, Al, how challenging it is to look at a law that is as complex as LGPD and try to carve out priorities when in fact everything is urgent, everything is already overdue, when we're overworked and understaffed. But our feeling is that there are some very basic concepts that need to be clarified in Brazil, because in fact, this is a new topic. People are still grappling with issues of, who is the controller, who is the processor, what does a DPO do? So there are some very basic steps that need to be taken. And our aim here was to provide for a 2-year plan that very clearly sets out what we're going to cover over these 2 years. And unfortunately, not all important topics could be addressed immediately, but you have to start somewhere, So our regulatory agenda was approved by an ordinance by the president of ANPD, and it can, of course, be changed. In fact, we have within ANPD an advisory board that is still being constituted. And of course, this advisory board may in the future provide guidance for us to include other topics, and we will be completely open to addressing other topics that may become priority over this period. So in 2021, we have 6 issues we wish to address. One is our internal rules of procedure, our bylaws, so to speak. These have already been approved, and they provide for very clear rules on how ANPD will work, how different stakeholders can interact with ANPD, and how our decision-making process will happen. The second topic is our strategic planning, which we have already also published. And then we have 4 different issues to be addressed this year. One of them is providing specific rules for small organizations, for micro and small businesses. And this is a topic that I realize is very sensitive also in other countries, because it is enormously challenging for a smaller business with perhaps 2 or 3 employees to suddenly have to deal with, hiring a DPO and having data protection impact assessments and, taking notes of all their data processing activities. And when our law went through Congress, this was a very sensitive issue. And the law specifically states that ANPD is required to provide specific rules, exemptions for some of the obligations that are provided for in LGPD. And we're working on this. This was, in fact, the first issue we began to tackle because we have a very large number of small organizations here in Brazil, and our intention is not to provide unnecessary burdens, or barriers to entry of new markets. So this was the first issue we began to tackle. The second one is security incidents and data breaches. This is also a pretty sensitive issue since we've been facing some huge, enormous data breaches in Brazil over the last month, exposing data of, practically the entire Brazilian population. So this is something we're also working on. We have already provided for simplified forms on our website to allow controllers to notify us if there is an incident. We have provided some very preliminary guidance onto how to assess the gravity of a data breach and, in which cases to notify the Anpd, in which cases to notify the data subject. But this is something we're still working on. And in fact, for us as a small organization, it is also quite challenging to understand how we can deal with these many notifications in a strategic manner so as to attack, not specific cases, but the causes that underlie these different data breaches. So this is something we're also working on. This year, we still have to work on administrative sanctions. So as you may be aware, Lgpd also provides for administrative sanctions that may go up to fines of 50 million reais, which would be today, I don't know, $10 million perhaps. I'm not up to date on the conversion rates, but perhaps $10 million, which is quite expressive here in our domestic context. Our administrative sanctions are not yet enforced. They will come into force in August of this year. So until August, we have to work on our administrative procedures in order to apply sanctions and, of course, allow interested parties to provide for full defense and provide their facts and their arguments to make sure that we come to fair decisions. And finally, this year, we're also going to work on the issue of data protection impact assessments, which is an instrument that we also have in the GDPR and which is part of, sort of the accountability toolkit, measures that organizations can adopt in order to deal responsibly with data and to adopt a risk-based approach. And then next year, we have 4 other issues which relate basically to data subject rights, the role of the DPO, legal basis for data processing. And here we have more legal basis than the GDPR. We have 10 legal bases. GDPR has only 6, if I'm not mistaken, or 4, I could be wrong. And also international data transfers, which are, of course, a huge issue considering our digital economy and the fact that personal data transfers, are sort of the lifeblood that flows in the veins of the digital economy, is something that we're very much aware of. So what we have begun doing already is beginning informal consultation processes. It's important to note that our law requires us to hold very lengthy consultation processes before issuing regulation. So we have to go through regulatory impact analysis, then we have to have public consultations and also public hearings as 2 separate stages of our regulatory procedures. So these processes can in fact be quite lengthy. And I think the law is in fact correct in adopting this approach because the issues we are tackling are very complex. And I do agree that it's important to listen to all stakeholders. So what we've done at this point is added another stage of interaction with relevant stakeholders by creating, periods for people to provide comments on the issues we wish to tackle. So we have already had a request for comments on SMEs and also on data breaches. We were very happy to receive over 170 comments that totaled over 900 pages of contributions for us to read before proposing our draft regulation. So in fact, we have lots of work to do, but we've been very happy with the level of engagement we have received on these issues. And I think this reflects also how personal data protection in Brazil is becoming an increasingly important issue and how people are increasingly aware of the importance of handling data responsibly. And just to conclude these first 15 minutes, I'd also like to mention that within Anpd, as I said earlier, we have a multi-stakeholder advisory board. And this board includes members both from the public sector, but also from different sectors of society. So civil society, academia, people from a business community, people from workers unions. And we have also initiated the formal procedures in order to create this advisory board. The procedure is quite complex because we have to receive candidatures and then we have to come up with a list of 3 names, and these get sent to the President of the Republic, who then chooses 2 names for each spot. So this is also quite a complex process. And we were once again very pleased to receive over 120 candidates, which I think is quite expressive, with excellent names, excellent backgrounds. And now we're working on the paperwork in order to be able to come up with these lists of 3 names for each each spot. So I think this is, basically an overview of what we're doing at this point. I'd like to pause at this point in order to listen to your questions, Al and Rafael, and thank you once more for the opportunity of speaking.
You're going to need a very long vacation by the time you finish your first 2 years with this, because it's a very aggressive and full amount of work. But let me ask you on the GDPR question. Companies generally spent an enormous amount of time building compliance infrastructures to meet GDPR requirements, and large teams, engineering changes, just a lot of effort. And now we have Brazil's law going into force. Do you think, in your experience looking at GDPR, if you meet the requirements of GDPR, do you think you're on pretty solid ground in Brazil?
Thank you, Al. That's a great question. And in fact, as I mentioned, our legislation was very much inspired by GDPR. It's very similar to GDPR, but it's not identical. So I have seen many articles coming out, focusing on the differences. I say we should maybe focus on the similarities, because that's perhaps a more constructive approach. And I do think that it's important to state that as we work on implementing LGPD at Anpd, we're very conscious of the need to provide for international harmonization and for greater interoperability between different legal frameworks, of course, respecting the specificities and the nuances that each legislation may have. So in general, our law is quite similar. We have some, I'd say, some minor differences. For instance, as I mentioned earlier, we have more legal grounds for data processing. The GDPR provides for 6, and LGPD goes further. We have 10 different legal bases that allow data processing, including one which is, I think, fairly unique to Brazil, which is a legal basis for protection of credit. So if you're a data controller and you need to protect credit, you are entitled to process data based on this, legal provision. And of course, our legal bases require further interpretation. At this point, there are still many questions, but I'd say LGPD is perhaps more generous than GDPR in the sense that we have more legal bases. Our access rights are also quite similar. So we have the basic ARCO rights: access, rectification, correction, opposition. There are some minor differences. Perhaps an important difference to state is that we have a smaller deadline to respond to access rights. We have 15 days in our law. I think GDPR provides for 30, which can then be further extended if I'm not mistaken. But this is also a point where LGPD allows Anpd to provide additional regulations. So it's something we can perhaps work on in the future in terms of providing greater harmonization. In Brazil, there is also the requirement to appoint a DPO. So our law is framed in a more broad manner than GDPR, but it also allows Anpd to provide for exemptions, especially for smaller businesses. So I think there's also room for further harmonization. We have fines as well as the GDPR. Our fines amount to up to 2% of the company's revenue in the previous year, limited to 50 million reais, approximately $10 million. And in Europe, the fines, I think, are a bit higher, 20 million euros or 4% of the company's turnover. So LGPD is also more friendly in this sense for businesses, of course. We also have rules concerning notification of security incidents and data breaches. LGPD says that these notifications need to occur within a reasonable time frame. Anpd has provisionally said that 2 working days is reasonable, but of course we're going to further work in regulation. 2 working days is approximately 72 hours, which is what we have in Europe. So I guess it's fairly similar. I think those are the main points of difference. And as you can see, Al, they're not really so dissimilar. They're quite, they're quite similar. With regards to international data transfers, we also have the same portfolio of mechanisms, which include adequacy decisions, safeguards, seals, certifications, code of conduct, consent, and so on. So I do feel that we will be able to develop LGPD working, on focusing on the similarities and not so much on the differences.
And Rafael, I'm going to ask you a question in a second, but Miriam, could you just clarify? I understand the administrative sanctions are August, but the law is in force right now. Is that right?
That's right. So in Brazil, everything is very complicated, and our law was postponed for a few times, and now the law is in force, but we are not yet able to apply administrative sanctions. They will come into force in August.
Okay, are they retroactive?
No, no. We have
Okay,
due process in Brazil, you know, the whole thing.
Yeah.
So they will only be able to be applied after August 2021.
Great, okay. And so Raphael, from your perspective, hearing the differences or the similarities with GDPR and dealing with global companies as you do, what's the reaction to where things stand in Brazil with the LGPD right now?
Well, first of all, I'd like to say hi to you, of course, and to say hi to Miriam, and actually congratulate Miriam and all the other commissioners and the staff of Anpd that have done a wonderful job in here. We have having a face to Anpd, having a voice. They've made themselves extremely available in the past, what, 4 months, 5 months? It's nothing. But they are out there and trying to convey their message, and they have shown that they're really working hard under really difficult circumstances that we are all going through. But they are trying their best, and that I can certainly say for sure. Now, practitioners, unfortunately, we tend to read the law into the very details. And at the same time, our clients come back to us with facts that we have never imagined that are actually reality. So I think this is what the challenge that we face, because the law is new. We don't have guidance, but in fact, we have very local issues for global companies that have to deal with CCPA, GDPR, other jurisdictions and ours. And they say, how can I have a centralized management if I have so many jurisdictions to attend to? So, for example, DPO, in certain jurisdictions, you don't have the need for that, but you have a need in Brazil, etc. So this has been quite a challenge, but there's one issue that I think that if Miriam, if you'd like to talk about, I'd be very pleased, which is international data transfer, as you said. It's in the regulatory agenda for next year, first semester, but also, as you said, it's the lifeblood of companies. And what are we going to do about this specifically until then? The companies, are they out there in the open, ready to be sanctioned when August comes, or should they take the precautions that they've been taking worldwide on a global basis? And one more thing, just a detail, and how, I don't know if the authority has even discussed that, but there are different countries with different jurisdictions and different laws. Not every country has GDPR or GDPR-like legislation. California, for example, that particular state has one thing, and there are pieces that they're not there in GDPR, no DPO, no restrictions, international transfer. They don't even have a federal law in the US. So how are countries like that viewed when you have to make your list of pre-approved countries?
Thank you for the question, Rafael. I do appreciate how challenging it must be to operate globally when you have 130 countries with different laws, with minor differences between them. And in fact, I think most of the discussion we've been seeing at international organizations, at OECD, at WTO, you know, everywhere, deals with this issue of international harmonization and ensuring that data can flow across jurisdictions while retaining a high level of data protection. And in fact, I think international data transfers are a huge issue. We recently saw the Schrems II decision and the impact it had on the privacy shield. And, you know, many figures were mentioned in the newspaper reports on, you know, what the economic impact of such a decision was. And I think in Brazil, we are certainly trying to make the country, you know, a good destination to receive data, and also a country that is able to export data in order to take part in this growing digital economy. So our law, in fact, provides for these different mechanisms, this toolkit of mechanisms involving adequacy decisions, also seals, certification, code of conduct, binding corporate rules, standard contractual clauses, as well as the possibility of transferring data when there is explicit consent from the data subject. And I think the challenge at this point that Rafael was referring to is that most of these mechanisms require regulation from Anpd, or at least guidance. And as he also very correctly mentioned, we are not yet 5 months old, and people are still grappling with issues such as who is controller and who is processor. So we have not at this point yet been able to issue this guidance that I feel is very necessary. We have, although we have not yet formally begun a regulatory process, we have begun discussing this issue with our counterparts in other countries. So we already have discussions with ICO and DCMS in the UK. We have a cooperation going on with the European Commission involving not only international data transfers, but also capacity building and exchange experiences. We have had good discussions with DPOs in other countries, also here in Latin America, also with the FTC. So we're starting to work on figuring out what is the best approach for Brazil. And in fact, at this point in time, I think that, while adequacy decisions are something that, of course, are important and facilitate data transfers enormously, they are procedures that are quite complex and that require also a certain level of negotiation at the diplomatic level. So at this point in time, I think what we're looking at most carefully is standard contractual clauses, because there's sort of an easy off-the-shelf mechanism that companies, be they large or small, can very easily introduce into their contracts and then transfer data onwards, with less confusion, with lower costs, and with a lower regulatory burden. So this is something we've been working on, and we expect to have answers, concrete answers next year. But Rafael's question remains, what to do in the meantime. And in this sense, I can mention that our president very recently, the president of Anpd, of course, recently took part in an event where he mentioned the possibility of discussing provisional rules, transitory rules to enable data flows to carry on while we work on this regulation. And of course, our law, although it is quite prescriptive in some aspects, it is also very much principle-based. And one of the most important principles in Lgpd is that of good faith. So I think at this point, it wouldn't really make sense for us to apply sanctions for companies who don't obtain explicit consent, because consent is, of course, not an appropriate legal basis if you're deciding where to put your data center, in Brazil or somewhere else. So I think at this point, we're trying to look for responsible behavior from data controllers and data processors. And while I cannot at this point, say do this or do that, I would like to make sure people know that we are very much aware of the issue, and we're looking forward to working on it as soon as possible.
So if the law is in force and there remains uncertainty, are there risks from private causes of action? Should Mr. Schrems move to Brazil? And what do you expect there?
Well, I do hope Mr. Schrems doesn't move to Brazil anytime soon, because we still have a lot of implementation work to do before we're ready to deal with this sort of a lawsuit. I think there is some legal uncertainty at this point, and at Anpd, we're working very hard to resolve these issues as soon as possible, but also recognizing that, we were created rather late in time. So the law was already approved, and only 2 years afterwards was Anpd created, while the law was already in force. And now we're sort of, running after the time that was lost and trying to put things in place as soon as possible. I think from our side, it's fair to say that it doesn't really make much sense for us as an administrative body to apply sanctions to companies that simply have no way of complying with the law because it's not yet regulated. It would be legally impossible to require companies to conform to rules that are not yet fully fleshed out. But I do really realize that for businesses, this situation is not ideal, and we are working on providing more clarity on this issue as soon as possible.
Can I?
Please.
Albert? Yeah. And it's okay. Hey, Miriam, does that mean that when you're on mute?
I hear you. Go ahead, Rafael.
Thank you. And by the way, I have seen your girl in other webinars. So that's perfect.
He needs me to glue a piece of paper in his notebook. So go ahead, I'm listening to you
Of
while I'm
course,
also
of
being a
course.
mother.
Yeah, on top of that. But what I was saying is, your answer suggests that when the time comes for Anpd to impose sanctions, is it correct to say that they will be more of an educational nature rather than money collecting action? I mean, is that a fair assessment?
Yeah, I think that's a very fair assessment, Rafael. And in fact, it's important to note that fines that Anpd applies do not go directly to Anpd. They go into the general treasury of the country. So for us, we don't really have an incentive to apply fines per se. You know, fines are a mechanism to incentivize compliance and probably not the best mechanism that there is out there. So as we've been working on developing our administrative procedures for applying fines, we've also been studying very deeply mechanisms of smart regulation, more responsive approaches towards compliance. And I think what we first of all wish to ensure is that in fact there is a change, a cultural shift in terms of data protection. And before applying, huge fines, what we wish organizations to do is to improve their internal procedures, to correct issues that may be inadequately addressed. And I think fines are, I wouldn't say they are the last resort, because they are, of course, very important in some circumstances, but they're not something we would, immediately jump towards applying huge fines. We are very much looking at the experience also of regulatory agencies in Brazil, where we have already 20 years experience and tens of millions of reais of fines that were applied and were in many cases not paid or taken to courts. And I think our priority at this point is to incentivize better behavior by organizations and not necessarily to apply fines.
Is it clear who actually is covered by this law? Is a platform in the US doing no other business in Brazil, but interacting with Brazilians who visit that site and whose data thereby is collected for reading, education, whatever? Are those entities at risk under this law in your view?
Right, so Lgpd does have extraterritorial effects, in a manner that is quite similar to GDPR. And our law states very clearly in Article 3, right at the beginning of the law, that the law applies to any processing operation carried out by a natural or legal person or legal entity in public or private law, so both public and private sectors, irrespective of the means, the country in which the company is headquartered, or the country where the data is located. So as long as a company is processing data in Brazil or targeting the Brazilian market, this company may be subject to Lgpd. And this, of course, is quite challenging for international organizations, but also for us in terms of enforcement, because unlike the GDPR, we do not have a formal requirement of companies having a representative in Brazil. So I think this raises another kind of challenge, which is, well, if a company is based in, Iceland or, Syria, and they're targeting the Brazilian market, how do we actually make sure that enforcement is effective? But our law does have this extraterritorial effect. And I might add that this is a mechanism that we also have in Marco Civil da Internet, which is our civil rights-based law for the internet. So this is not really something new in Brazil. And at this point in time, there are discussions before our Supreme Court concerning, for instance, obtaining evidence that is held overseas. I realized that this discussion was also held in the US. You have the Cloud Act, and we have an unresolved discussion before our Supreme Court, but I think the situation is quite similar.
Right, and so to be clear, when we talk about public entities being covered by Lgpd, there is the exception for national security and law enforcement, though. Is that right?
Right, so there is an exemption for specific purposes. Let me here. Lgpd does not apply to activities related to public safety, national defense, state security, or activities of investigation and prosecution of criminal offenses. However, this was quite a complex discussion in Congress, and our law does state that these activities will be governed by a specific law and that general data protection principles and rights will apply. So there's currently an open debate if these principles already apply to these activities or if they will only apply once the future law is approved. And there is in fact a bill of law that is currently in discussion in Congress, and that has created quite heated discussions, because on one side we have the law enforcement people, and on the other hand we have people concerned with human rights and personal data protection. So I think it's quite a tricky discussion, and it's currently before Congress.
Great. I want to remind the audience that we do have a Q&A button at the bottom. You can submit some questions, and I am watching those questions to see if they're covered in our discussion already. But if you want to add any questions, please do. And in the meantime, we're going to keep talking for a few more minutes. And I'd like to change gears just a little bit and ask you a little bit more about how the current COVID crisis, the healthcare crisis, has affected really how you and how the ANDP look at privacy in a public health environment, particularly one that is so challenging and widespread is this. Can you talk to that for a minute?
Sure, of course, Albert. And it's a great question. And in fact, in Brazil, it was interesting because the pandemic arrived before LGPD was actually in force. And, everywhere, I think worldwide, we saw this trend of the pandemic creating increased needs for data sharing, both between public organizations, but also public and private sector, and between private organizations dealing with, healthcare and research, for instance. And we were here in Brazil seeing the pandemic approach our continent, and we were very much aware of what was going on in Europe and in countries in Asia, where they had, very specific measures that were aimed at containing the pandemic, such as, contact tracing and geolocalization. And at the same time, we saw DPAs in other countries being very clear about the limits of data processing under these circumstances, saying that, of course, data sharing is possible to, face a major pandemic, a major sanitary emergency. But on the other hand, certain rights of the data subject must be observed and certain principles must be taken into account, including the principle of purpose specification, purpose limitation, for instance, in order to prevent this huge amount of data to be used for other purposes later on. And here in Brazil, we didn't have a DPA in force. We had a law that was not yet in force. And at the same time, many different measures were adopted by local governments and also at a certain level, at the federal level, to face the pandemic. And this led to lots of action by courts. So many lawsuits were presented. We had initiatives, for instance, in São Paulo and in other municipalities and states for geolocalization. So telco data was used in order to provide heat maps to figure out, where there were most people or if they were moving about a lot. And this was actually taken to our higher courts. And this sort of measure was considered legal because the data was in fact anonymized. So there was not much of an issue there. But there was another case which was actually really important, which involved data sharing between telecommunications companies and our National Statistics Office for the purpose of carrying out statistical research during the pandemic. And it was a really interesting case because a provisional measure, which is it has the force of law. It's issued by the President of the Republic, but has force of law. So a provisional measure was issued demanding that telecommunications companies had to share certain data with our National Statistics Office. And the data was basically the name, the surname, the national identity number, and the telephone number to enable these statistical researches to be carried out by telephone. And there was, in fact, lots of discussion on this provisional measure, and it ended up with the Supreme Court considering that it was unconstitutional because, in fact, it had not respected basic rights related to informational self-determination, to the proportionality of this sort of data sharing, also issues related to cybersecurity, how this data was going to be, in fact, stored. And this actually was a landmark case here in Brazil because for the first time, our Supreme Court recognized the existence of an autonomous fundamental right related to data protection, which goes beyond the right to privacy, the right to be left alone, but includes also data that is publicly available or data that is not sensitive or intimate in some manner. So this was actually really important. And afterwards, we have seen the Supreme Court deciding several cases that deal with data protection based on this idea of a fundamental human right to personal data protection and self-determination, which is also the language that we see a lot in Europe, specifically in German, where this idea of informational self-determination was in fact very important in the 80s, well, where there was also a decision by the Constitutional Court. So the pandemic in a manner has also been very important for us here in Brazil, because our general data protection law and the Anpd sort of came into existence while the pandemic was ongoing, and while both public and private organizations were struggling to, move everything online very quickly. And this in its turn raises also a number of other risks and possibilities in terms of data processing. So I'd say that while we did not have experiences related directly to contact tracing and Bluetooth apps, as we saw in other countries, the pandemic did, provide for very important effects here in Brazil regarding data protection.
Do you see on the horizon contact tracing apps and other technical means? And if so, because this pandemic doesn't seem to be going away as quickly as we'd like, and if so, are those things that would be driven by governmental regulation, or would the private sector be able to come in to assist in developing those and be relatively comfortable in the way they did it?
Well, I'm not an expert, but I do think that contact tracing apps are perhaps more useful at the very early stage of a pandemic, when it still seems possible to track the virus. And at this point, we have a very widespread virus and different variations and so on. So it doesn't seem very likely to me that we will have governmental initiatives regarding contact tracing in the near future. But you never know. Perhaps when we have more vaccines and the virus comes back into control, this may be something on the horizon. And if this happens, at least we will have a data protection authority to provide more guidance on what can be done and what shouldn't be done in terms of data sharing and data processing.
Thank you, Miriam, and that. Rafael, did you want to add anything on the pandemic side?
No, I don't think so. I think the inputs from Miriam were terrific, and I'm seeing here lots of questions from the audience.
I was just going to segue to that,
and some are very interesting.
Yes, so I'm going to just read these, Miriam and Rafael. You can feel comfortable, each of you joining in, and we'll take the rest of this conversation to respond to some of these. Do you see legislation that specifically covers public interest data and data sharing for Brazil?
I think that's a really interesting point, Albert, especially as we look at the European Union, for instance, and the whole discussion on B2G sharing and data for good. And I think here in Brazil, we are somewhat behind, because we've only just had our law come into force, and we're still trying to figure out how it applies to the public sector. And in fact, our Supreme Court has already taken some important decisions limiting the sharing of data between governmental bodies. So I think we still have a way forward to move before we begin discussing B2G sharing and data for good. It's interesting to note that I believe the OECD is currently discussing a draft recommendation on data sharing in a more general manner, and Brazil is of course participating in these discussions. So I think it'll be interesting to see how the OECD discussions influence the Brazilian debate, but I don't see a law on this anytime soon. I think we still have to figure out how the Lgpd works before we can begin discussing in more detail B2G sharing and data for good. Yeah,
it's interesting. I think that data privacy for citizens, for Brazilians at least, data privacy is still is an acquired taste. We, in general, people don't have the same regard for data privacy or the protection of their data as in other countries. So we're still going uphill on that. And perhaps we're not, as Miriam said, not there yet for this kind of legislation. But things are moving fast.
Okay. In a pragmatic approach, how can Brazilian companies determine when there is or is not a legitimate interest to obtain and process the data of its customers?
That's a wonderful question, especially when it's phrased, in an abstract manner. Our law does provide for the legal basis of legitimate interest, and it also states that it's necessary to carry out a balancing exercise in order to verify if the legitimate interests of the data controller are, not superior, or if they can be balanced with the legitimate expectations of the data subject. Our law is not, very detailed on this point. It provides basic information. And as I mentioned earlier, next year, we hope to provide for more detailed guidance on the different legal bases. And next year, therefore, I'll be able to provide a more complete answer.
Okay, fair enough.
Yeah, there is a specific question whether the interpretation of legitimate interest will follow GDPR. It's a low-hanging fruit, isn't it, Miriam?
I think it does make sense for us to try and, keep interpretations as similar as possible to what is going on in other countries, and not come up with, new innovative manners of understanding concepts that are already, disseminated worldwide. So I would imagine that it makes sense for us to adopt the GDPR approach, but of course, we still have some way forward. We still have to go through some steps before we can have a final response.
So this is an interesting question to me, and it's an easy one. This is a softball. Since LGPD has global impact, what efforts will Anpd make to have guidance and updates accessible in languages other than Portuguese?
Albert, I was thinking about that the other day, and it may be surprising, but we don't have a team of interpreters within government who can work on translating documents. I remember a few years ago, I was working at the Ministry of Science and Technology, and we were working on an important policy for digital transformation. And we had a publication of about 100 pages. And I remember saying to my team, you guys, we need to have this in English. And we sort of shared the document between our team members, and we translated it ourselves and put it online. So it was, a team effort. And I do anticipate that it's important to have our documents in English at some point. But at this time, we still do not have enough manpower or woman power to get them all translated. I do hope we will be able to, though, in the near future.
I think you could have a study commission with the European Union on the annual cost of publishing every privacy or other directive in the multiple languages that they must do under their laws. It's an astonishing amount of money that goes into preparing those documents in every one of the 48 countries and the multitude of languages they have to do. So it is a real challenge.
It's really expensive. And also this is very technical language, so we have to be very careful about the interpretation. The good news, Al, is that many important law firms in Brazil have been taking it upon themselves to do this. So I have seen some versions of the Lgpd translated into English, and I see Rafael is smiling at me. So who knows, maybe Pinheiro Neto will be translating our guidance anytime soon.
Well, right. you haven't asked yet.
Yeah.
It'll be a pleasure, really.
Yeah, it would be a gift to many, for sure. So this is an interesting question as well, and again, I'm trying to get as many of these in as I can. So apologies if I do miss somebody's. I want to go back here to the private cause of action again. Not surprising, there are a lot of questions that seem to be very concerned about the potential financial risk. And it says, one common concern for businesses in Brazil is the private right of action. Lgpd does not set a cap like CCPA and HIPA. In light of the culture that Brazilians have to sue so easily, is there any discussion about limiting or setting guidances for the PRA, private right of action?
Right, so that's a great question, Albert. And in fact, in Brazil, it's fairly easy to sue, to go to courts. In fact, in some cases, you don't even need a lawyer. So it is a very challenging scenario. And I think one of our main goals here is to avoid mass litigation. So we don't want people to go to courts every time they have an issue concerning personal data, because perhaps courts are not best positioned to interpret a complex law such as LGPD. And what we have been doing is working firstly on speaking a lot to the judicial branch, to different courts who themselves are also subject to LGPD, but trying to raise awareness among judges and members of the judiciary branch. We have the possibility of working with CNJ, which is our National Council of Justice, which is a body that sort of organizes courts in Brazil. But I don't see the possibility of establishing a limitation for the right to litigate, because this is in fact a constitutional right in Brazil. Anybody is entitled to go to the courts to complain about whatever they like. So I think our effort has to be to resolve things administratively and provide lots of clarity and lots of guidance and lots of incentives for compliance in order to avoid these problems of litigation. I think we have some good examples in Brazil on how to, resolve issues administratively before going to court. So for instance, in the consumer protection sector, we have a digital platform called consumidor.gov, which enables consumers to, file their complaints, and then companies respond directly, and they sort of figure things out without having to take this to courts. And I think that LGPD also provides incentives for us to establish mechanisms of this sort within Anpd. So we have been discussing with our National Secretariat of Consumer Affairs and also with regulatory agencies in terms of trying to figure out what they've done to reduce mass litigation. And it's something we certainly have in our list of priorities.
In the US, we have a doctrine of ancillary jurisdiction in courts. So where an expert agency has not ruled on a particular topic, a court might defer the question to that agency until such time as the agency can promulgate a rule or a decision. Is there a similar option? Could ANDP intervene in a case or tell a court that they request the decision be delayed, or it might rearrange your priorities in responding to questions?
I don't think we have anything formally similar to what you described, Albert. Of course, when there are cases before the Supreme Court, Anpd could intervene as amicus curiae, for instance, providing additional arguments or elements to be taken into consideration. Also, our judiciary branch traditionally is quite respectful of administrative decisions. So many times you'll see judges saying, well, this issue has already been decided by the competent body within public administration, so I'm not going to look at the merits of the issue, but only to check if formal aspects were observed. So I think there are ways forward for us to reduce the risk of, fragmentation of the interpretation of LGPD, but perhaps nothing as simple as you described. But I would like to hear Rafael on this point, because he may have other views on this topic.
Well, my other view would be there is a field there for law techs and platforms, absolutely, that could pursue manners or could introduce channels for consumers to address their concerns and directly to the companies. I think this is a great thing, and we definitely need that. As to restrict the rights of individuals to sue, I think this is a very thorny constitutional issue, and I don't think that in Brazil we would have exclusive right for jurisdiction with the Attorney General, for example, as you have in California. I think that I insist maybe law techs are the solution here.
Okay, we actually are at the hour and a little bit over. I have a yes or no question I think is an easy one. And then I think we can just wrap up with some concluding comments quickly, and apologies again if we couldn't answer all of your questions. Will you seek an adequacy decision from the European Commission, and what is your plan in doing so? You can either answer yes or no, and then not answer the second half in order to make it a yes or no answer.
Yeah, I think this is something that certainly makes sense for us to seek, because we have a law that is so deeply inspired in GDPR. It actually wouldn't make sense for us not to pursue an adequacy decision. At the same time, it's very hard to put a time frame on this. Firstly, because the European Commission is dealing with a UK adequacy decision, which is complicated enough, I think. but also because I think we still have some steps to take in terms of, implementing our own legal framework and also dealing with Anpd's legal structure, which is at this point perhaps not ideal from a GDPR perspective when we think of independence and autonomy. So I think it might take some time. These decisions, I believe, are not quick. Someone told me a couple of years before the European Commission decides. So I think it's something that's definitely on our horizon, something we look to do in the future. But as I mentioned earlier, perhaps in the short term, we need easier mechanisms to enable international data transfers, such as SCCs, for instance.
Great. Miriam, any closing observation, any key point you want people to take away from today?
Well, I'd just like to say thank you once more, Albert and Raphael, for the opportunity of speaking to this audience. And I do hope that the information I've provided has been helpful somewhat for people to understand what's going on in Brazil. I'd like to say that at Anpd, we're very open to understanding the concerns of the different stakeholders, be they big or small organizations or data subjects. And we're working very hard to implement this legal framework that is extremely challenging, but that also provides us an opportunity for, stepping up and joining the other 130 countries in the world that have legislation of this kind. So I'd like to say, please feel free to reach out to us. We'd be very happy to receive comments, suggestions, any kind of input that you may feel is relevant. And thank you once more, Albert and Roland and Raphael, for the opportunity.
Okay, thank you, Miriam. There are a number of questions that didn't get answered, and in light of your invitation, is there a place they should ask those questions directly to the ANDP, or what would you recommend out of today's session for the number of questions we weren't able
Well,
to?
I think I could suggest the following. We do have an official email called anpd@anpd.gov.br, but we in fact find it quite challenging to answer individual questions. So we have been trying to receive these questions and treat them in an aggregate manner and figure out what are the topics that are creating, most questions or most doubts, or what are the issues that are troubling people the most. So what I will do is copy all these questions into a Word document and take them back to the NPD and share them with my colleagues so that we know, what's concerning people, and then we can handle them appropriately. Also, if anyone wishes to write to me directly, my email is miriam.wimmer@anpd.gov.br. It's very simple, so please feel free to reach out.
That's very generous. Thank you, Miriam. Raphael, any parting comment from you?
Other than suggesting that ANPD adopts artificial intelligence for answering the questions, but that's no. I think this has been fantastic. Many companies that we work with that are out there in the Silicon Valley, they've always asked me what is ANPD like, and there's nothing better than bring ANPD's face to them directly by this event. And as I said before, I congratulate Miriam for her openness in reaching out to the public at large, and to the Law, Science, and Technology program for putting this together.
Yes, thank you, Miriam, Raphael, Roland. And with that, I wish everybody a safe and happy day ahead. And maybe we can do another one of these soon, Miriam, if you have an hour anywhere in your foreseeable future free. So I wish you a lot.
I'd be delighted, Albert. Thank you very much. I'd be delighted to come again. Thank you.
Thank you. And goodbye, everyone. Bye-bye.
Bye. Thank you. Thank you.